O'clock hour. Thank you so much for still being with us here on Morning at NTV. NTV turning 20 in the year 2026. So we are here. We have 2 decades of experience, but the same bold voice. And we're bringing a bold voice on the 2026 general election petitions. Is the legal threshold too high to actually overturn elections? That is where we are taking notes today, this morning. I am Priscilla Regina Nalwoga. Now, in Uganda's courts, it's not enough to prove that electoral irregularities occurred. Petitioners must go a step further and demonstrate that those irregularities substantially did affect the final outcome. Now, legal experts are saying that this sets one of the highest thresholds in electoral law across the region. But does this standard actually safeguard the integrity of elections, or does it make it nearly impossible to successfully challenge the flawed results? I'm being joined by High Worship Prosi Katshabe, who is a registrar in the High Court and an expert on electoral law, to give us the extensive experience on election petitions and the judicial processes that be in Uganda. High Worship, you most welcome and good morning.
Good morning. Thank you so much.
It's a pleasure to have you. Now, let's begin with a scale of the election disputes. If we go to the elections, Uganda saw 104 parliamentary petitions of 49 local government petitions filed before the courts. This is in reference to just 2021. And what these figures do give us a sneak peek into what could now be in 2026, with some still considering if they should go to the courts to seek justice. What do these figures mean in terms of elections, in terms of public confidence in the electoral process of seeking justice?
Thank you so much. That was a figure in 2021, and we are now already receiving, we have received most of the petitions, and the process is ongoing. People filed as the law requires, and then there were applications, some for substituted service, some with all sorts of legal issues that come when somebody files a case. I want to say that every election cycle comes with different challenges and unique things. For example, in these election petitions, we've seen the introduction of biometrics. So that's like a new thing. So that also goes to the legal regime that comes with it. So I want to start by saying that in this legal regime, we've had so many pre-election matters because, parties had tribunals, you'd appear in NRM and then they make a decision, the flag bearer, the one who is not. So that brought a lot of cases. So the courts handled those cases. I can say we handled about 117 pre-election matters, which were concluded before the elections could come into place, and decisions were given.
And what's the log on the current cases post-election?
Okay, so post-election now we have over 118 cases filed in court. And the local government, they are still filing. But for parliamentary, we are now sure of what has been filed because the law gives a time limit for filing. So we are done. In local government, there's no time limit on filing, but there's a time limit when they start hearing the case. So parliamentary, we already know what is cut out for the judges. We are preparing, we are ready, and sooner or later, within a few weeks, we should be able to start hearing the petitions.
Okay, so when you start hearing the petitions, what's the consideration there? Because now those parliamentarians, most of them are being sworn in a few days, we can say, because now we're entering May.
Yeah, sure.
And so what's the procedure like in order to get the hearing and also the decisions made on those cases?
Yeah, so the law provides that you file your petition within 30 days after the gazette, the gazettement of the results. The processes that are going after do not affect what court will do. I think you've seen in the last cycle of election petitions in 2021 that there were some overturnings of some people. There were others were with the members of parliament. They had to go back and do a by-election. So whether you're sworn in, still court will continue with its process. That doesn't stop them. But what I want to say is that the cases were filed and there are processes that go on. And we are in those processes, we are planning, and soon they will start. So the processes, the other side are going on, but the court can overturn any process that has already been done, or the process can confirm the process that has already been done.
Okay, speaking of processes, there's also concerns about the procedure. Courts dismissing petitions over technical issues, improperly commissioned affidavits, or even missing documentation. I would like you to speak into that. Are legal technicalities actually taking precedence over the substantive electoral justice?
Okay, thank you. I don't think that technicalities are taking over. What I want to say is that as courts, procedures are part of the court process. And procedures are handmaidens of justice. They are to help us to come to a proper decision. So the dismissals that happen, I think in most instances there are very many glaring irregularities or issues to do with the procedure, the technicalities. So it's not that courts actually just depend on the technicalities to dismiss the cases. But as you know, in cases, when you look at cases in the last 2 election cycles, they have put, the standard is the balance of probabilities, not beyond reasonable doubt. But in election petitions, the standard is slightly higher. You must be prepared. This is for example, I can give a woman member of parliament. This is a whole district that is voting. If we're going to do another by-election, it means that the whole district, the government has to go out there and again call the whole district into order. So the standard is slightly higher, and I'm not saying that that's the reason why they dismiss, but that's part of our normal court processes. We have procedures and you must follow procedures. And if you're coming to overturn an election, you must prepare. So usually technicalities come in where people have had flaws in the procedures that have been provided in the law. But that's not what they depend on, because in some instances, some elections have been overturned, some have been appealed and said, you know, you are raising this as a technicality, but the Constitution says that justice shall be done without undue regard to technicalities, Article 126. And there you go. You have your day and the technicalities have no effect on your case. Thank you.
So perception of the public is the perception of the public, but through your office of the registrar, I know that there's ways that you're trying to address these perceptions so that you can increase people's confidence in the judiciary and the processes. How are you doing it?
What we do, this is one of the things we are doing by coming here and giving people confidence that when you file your case, and you go through the normal court process, you will get justice. So by being hosted here and talking to the public, that is one way we tell the public. Another way is that our judgments are published. So if you need a reference, you say what happened in 2021, you can actually see what happened in 2021 and now. And now the parties have filed cases and the processes are ongoing. It's not that there's nothing that's ongoing. We've not started the actual hearings. But when we start the actual hearings, what happens is we'll do it day to day. And that's why we need to prepare. The judges need to do vigorous preparation. The judiciary needs to do vigorous preparation. That when we give you a date, the member of parliament, the one who is contesting, the one who lost, the public, they are very certain that this case is going to be heard more or less in not more than 30 days, and it will be done. The law gives us 6 months to have finished the petition. But as judiciary, we also put on it and say, no, let's do this case first, because we know about what justice delayed is justice denied. So when we start hearing the actual petitions, we are done with the applications, the preliminary objections that have been raised, cases will be heard on a day-to-day, and they'll be finished very fast.
Okay. Turning specifically to the 2026 general elections, you did make mention of one of the unique ones for this election, the introduction of the biometric machines in the process of elections. That now being a game changer for, you know, the legalities that you have to deal with. There was also the internet shutdown that people have presented, allegations of ballot stuffing, and many other things. At what point does such systemic issues actually meet the legal threshold required to then overturn an election?
Thank you. Now that, like I started at the start, I told you that every election cycle comes with a different legal regime. It comes with different challenges, issues. That is like something that came up. So we are also waiting. I'm hoping that somebody out there in the public or a party who lost an election, because you know the law provides that it can be a party who has lost or a member of the public supported by 500 signatures actually has challenged that in those 100 plus cases we have, so that it can be tested legally and decisions are made. So that's like part of what we hope that is going to be in part of evidence or wherever, for example, where those people had the biometrics working, what were their challenges, or how are they presenting that piece of evidence in court so that the judges can analyze it. So we are waiting to see how the cases are going to go and if that matter is going to be brought out, and then maybe there's some jurisprudence that is raised about using of biometrics and the shutting down of internet.
Okay.
What was its effect on the cases, I mean on the this election cycle we have finished.
Okay, so let's look at previous cases at which judges have sat down, analyzed, and passed judgment and even recommendations, especially through the presidential petitions that have happened in previous years from 2001. And so we see recommendations being made by the judiciary after some of those unique cases, and we want to understand why the court then consequently does not identify these faults. I mean, it does identify the faults, it does make its recommendations, but it does not lead to annulling of elections as expectations of the people. And I think we can make reference to the case of Kenya in 2017.
When we talk about the presidential election petitions, there is a legal regime that takes care of presidential elections. That is the Presidential Elections Act, that is different from the Parliament. So the law gives grounds for setting aside. I know that cases have, when the cases that have been had before, and the decisions have been made not to overturn the election because of the substantial bit. Unfortunately, in this cycle, the petitioner withdrew the case, so we didn't get an opportunity to test that principle again and see what are the current judges of the Supreme Court saying about that. But what I want to say is that the Supreme Court saying that the election petition should be handled at the hem of the judiciary is to also keep the stability of the country, not to have challenges. We need to, justice is about the law and looking at the evidences. We do not just say we make decisions. I'm sure the judges looked at the evidence, they looked at what was given, the threshold, the margins, and came up with that decision. So it's difficult to now say that that is what is the trend. Currently, that is the decision of the court, and we're bound by that. Until we get another decision of the Supreme Court, it might be difficult to say. Unfortunately, this year we've missed it because the case was withdrawn.
Okay.
Yeah.
So what message would you give to the public, especially when in their minds that should then automatically translate, the recommendation should automatically translate into law that should lead to annulling of an election? What is your voice of opinion to them?
My voice of opinion is to the public is that keep your confidence in the judiciary. We make recommendations, we do not make law. So when we make recommendations, the recommendations are supposed to be done by another arm of government, which is Parliament. It's supposed to pick up those recommendations and put them into laws that we will apply maybe the next election cycle. And you've noticed that most of the time, by the time we get to another, there are so many amendments that have been put in place, meaning that actually the legislature considers what it considers and what doesn't consider. The judiciary is not a party. For us, we make recommendations and we expect that the executive is working on. But I want to say that the courts will always listen to the public, listen to the parties, look at the evidence and make a decision impartially.
Okay.
Yeah.
Because at the end of the day, we're here to also, extend sensitization and as much information to the different stakeholders. What would you have to share with stakeholders that are currently undergoing this process, especially in Parliament level and local government level? Okay.
So what I would want to share with the people who are currently involved in the process is that we have already received all the cases countrywide. Preparations are being made to dispatch the different judges to go and handle the cases. And within a short period, before the end of May, I'm sure we will have had the cases being heard. And so I pray that they will stay calm, stay put, present your evidence. The courts are not going to rely on what is happening in the country or whether the elections were done or the swearing in or other activities that are happening within the country, the courts are going to rely on the evidence that you have presented, and they will make the appropriate decision. Okay. So I want to give them confidence that that is going to be done.
And what would be your call to action? And also, what's the commitment on the side of judiciary to ensure that May is May?
I cannot give the commitment that May is May, but I know that it's going to be around that time. Giving that commitment, I mean, I'm committing the institution, but I know that we uphold justice, quick justice. That is one of our tenets, that we want cases to be concluded. So I'm sure that the cases are going to be handled very soon. What we usually do is that we communicate to the lawyers, we communicate to the parties, and then the parties know that the cases are going to be heard. The confidence I give them is that when these cases are set to be heard, when you're given a hearing date, come, because now we would want the cases to be heard on a daily so that you can have your decision very fast.
Okay. Yeah. Any other information you'd like to extend to the public?
Not really any information. I just want to tell the public that keep alert. The cases will be heard. I am sure NTV and many other media houses are going to keep you updated on what is going on in court. I am sure we will have such a good time following up on your candidates and what is happening in court when that time comes.
Okay, Her Worship Prosikat Shabe, Registrar High Court, thank you so much for sitting down with us and giving us a vote of confidence that the judiciary system is working tooth and nail day and night to ensure that justice is delivered to all the election-related petitions that have been submitted in the corridors and offices of justice. And so we await to follow up on many of these cases, and the commitment from the judiciary side is that by the end of May, most of these should be put to bed, especially for parliamentary and local government petitions. And so if the legal threshold is existing, then we're getting to see, governors, especially as far as judiciary is concerned, continuing on to make sure that all the other facets and elements of our country are actually in good line. That brings us to the end of this conversation, but we do have others coming up. Just take some water or a cup of coffee and return with me.